Me here, sir, today to organize this entire webinar lectures-based series. I must thank the efforts put in by the Bombay Incorporated Law Society and Mr. Jani, Mr. Nilesh Modi, sir, Mr. Jani, sir, and everybody on the panel here. I welcome the participants here who are going to hear me today. So before I begin, just three things I wanted to put forward. Most importantly is whatever I'm explaining here is for the benefit of understanding. Now you will have to take whatever I'm explaining in a format of how you want to write your paper in your own style. So when I say this, I want to include the basic concepts of it, not touching up the latest judgments, because that homework we'll have to do it and we don't have really a huge time factor here. So, and the third thing is the books that I recommend is my own recommendations. You can venture other books as well. So to begin with, I would say for High Court original side books, we can touch Mahendra C. Jain, which I had referred during my solicitors examinations, and C.K. Takwani for CPC, because these are user-friendly books. But of course, I'm not saying you must only follow these books. You can touch many other books on the student level. So let me begin with. Now I ask myself a question. Why do I study civil laws? Why do I study civil laws? Because I have to practice. Now for practice, the procedural law is very important. So when I say CPC, it deals with the procedural law and it does not contradict with the local or special law in force. So basically there are substantive laws attached to it. So when we go for procedural law, this is a Bible for us. We need to know the proceedings and we need to know what is important therein in our day-to-day practice. Because without CPC, we really cannot practice civil laws. So I will touch upon the important definitions firstly. And I'm not going to cover each and every definition. I'm going to take up definitions which are really essential for me to highlight before you all, and in practice, which would be essential for us to know. So when I see section 2, subsection 2, decree, what does a decree mean? Decree means a formal expression of an adjudication which, so far as regards the court expressing it, conclusively determines the rights of the parties with regard to all or any of the matters in controversy in suit, and may be either preliminary or final. It shall be deemed to include the rejection of plaint and determination of the question within section 144, but shall not include any adjudication from which an appeal lies, as an appeal from an order or any order for dismissal for default. Now, when I say this is the definition of a decree, now I have to understand this decree are of three parts, like three classes. Firstly, preliminary decree, final decree, and partly preliminary and partly final. So when I have to understand what is a preliminary decree, the clear answer is where adjudication decides the rights of the parties with regard to all or any matters in controversy in suit, but does not completely dispose of the suit. Still there is something pending. I have just determined the rights of the parties here, and that decree is called a preliminary decree. A preliminary decree is only a stage in working out rights of the parties, which are to be finally adjudicated by a final decree. So now a question comes, under what order do we see this? Order 20 basically deals with the matters which can be dealt with in the preliminary decree. Suits for possession and means profit, Order 20, Rule 12. Administrative suits, Order 20, Rule 13. Suits for preemption, Order 20, Rule 14. Suits for dissolution of partnership, Order 20, Rule 15. Suits for accounts between the principal and agents, Order 20, Rule 16. Suits for partition and separation of possessions, Order 20, Rule 18. Suits for foreclosure of a mortgage, Order 34, Rules 2 and 3. So besides the above, the court has the power to pass preliminary decree in cases not expressly provided in the code. Now, a very famous case, a very old case, which might not be relevant for you to answer, but we should know whether a preliminary decree can be more than one decree or no. So Fulchand versus Gopal Lal, AIR 1967, the apex court has decided that CPC does not prohibit passing more than one preliminary decree if circumstances justify, and the same, and it may be necessary to do so, there may be more. Now I'm coming to the final decree. A decree may be final in two ways. Firstly, when no appeal is filed against the decree within the prescribed period, or the matter has been decided by the decree of the highest court, there's nothing remaining. So I don't need to really file further appeal. Then this is final decree for me. Then when the decree, so far as regards the court passing it, completely disposes of the suit, there's nothing further remaining. My entire suit is disposed of. And this is a final decree. Now, when I go further, under the special circumstances, more than one final decree can be passed in the same suit. Where two or more cause of actions are joined together, there can be more than one final decree. Now the question comes, can there be partly preliminary and partly final decree? Let's see that. For example, in a suit for possession of an immovable property with means profit, the court decrees the possession of the property and directs an inquiry into the means profit. Now, which is the former final decree and which is the latter is the preliminary decree. Let's see that. The former part of the decree is final, while the latter part is only preliminary, because the final decree of means profit can be drawn only after inquiry and ascertainment of the due amount. So in such a case, even though the decree is only one, it's partly preliminary and partly final. Now, this is what we understand by a decree. Take an example. Like there is a big property, a huge building. There are two co-owners. One co-owner is saying, I question your right. I say you are not the owner of this property along with me. The court will say, first, let us decide whether this person was the owner or no. Then in that case, firstly, the preliminary decree has to be passed about determining his rights, whether he is the owner with this person who is saying he's a co-owner and he's opposing he's not the co-owner. So, and then ultimately after decision of this, the property disputes ultimately when finally heard and adjudicated would be final decree there. So we do see this combinations. Now, important point is many a times we do hear about, hey, the court has passed this order, that order. Let us know what is an order and how is it different from a decree. So section 214 defines an order. An order means the formal expression of any decision of a civil court, which is not a decree. The adjudication of a court of a law may be either decree or order and cannot be both. So let's see the difference. Now, basic difference in an answer, you should know how do you distinguish a decree and an order. Origin. A decree can only be passed in a suit which is commenced by presentation of a plaint, whereas the order need not be by only the presentation of a plaint. It can be by a petition, it can be by an application. So that is the difference here. We see the difference number one. Then determination of the rights. A decree is an adjudication conclusively determining the rights of the parties with regard to all or any matters in controversy. So it's conclusively in nature, whereas the order cannot be conclusive as a whole. So type of a decree is also important. Decree may be partly preliminary, partly final. Order cannot be preliminary as such. So no order or a number of order and decree. So in every suit, there can be only one decree, except in certain suits where two decrees, one preliminary and one final is passed. In case of a suit or a proceeding, number of order may be passed. Number of orders can be there, but decrees will not be too many in nature. Now appeal from, see, every decree is appealable unless otherwise expressly provided. Whereas on the other hand, every order is not appealable. Only those orders are appealable as specified in the code under section 104 and order 43 rule 1. Now second appeal. A second appeal lies to the High Court on certain grounds from decree passed in first appeal, section 100. Thus, there are two appeals. Whereas on the other hand, for the order, no second appeal lies in cases of appealable orders under section 104, subsection 2. So this is where we identify and distinguish the difference between a decree and the order in a nutshell. Many a times we do see whether this order, for example, order to restrain somebody from entering in the property appointment of the court receiver, is it appealable or not? We need to check. We need to see whether it falls into the order 43 and whether we can or we cannot. So every order cannot always be appealed. That is also important. Whereas decree on the other hand, if you're not satisfied, can be appealed as a whole. So let's see now, moving forward to jurisdiction. Now, very important point would be section 9. A civil court has jurisdiction to try a suit when following two conditions are satisfied. And it is a must. These two conditions must be satisfied, my friends. If it is not, then a civil court cannot have its jurisdiction. First, the suit is of a civil nature and the cognizance of such suit is neither expressly or impliedly barred. Now you'll ask me, what is the definition of civil? In the entire CPC, we do not get really the definition of what civil is. But to understand it, let's explain it here. The word civil means pertaining to the private rights and remedies of a citizen as distinguished from criminal, political, etc. The expression civil nature is wider than the expression civil proceedings. Thus, a suit is of a civil nature if the private question therein relates to determination of a civil right and enforcement thereof. It is not the status of the parties to the suit, but the subject matter of it which determines whether or not the suit is civil nature or not. For example, an election petition. Like, a person who is involved in it. So he'll be like not going absolutely for a suit. So we need to see which matters can fall into the domain of a civil suit, a civil nature, which disputes. Then accordingly, we must advise our clients whether, yes, this is a civil court jurisdiction and we must really file the petition suit here and we must proceed here. So this is what we need to understand, what is civil in nature, in addition to which matters can be dealt with in civil courts. Now, cognizance not barred. Court to try all civil suits unless barred. The court shall subject to provisions herein contained have jurisdiction to try all suits of civil nature, except suits of which their cognizance is either expressly or impliedly barred. I've already repeated that. So example, barred would be barred by limitation also sometimes. You really cannot now come forward after like 20 years and say, I want to file a civil suit, though the matter was already resolved and dissolved and disposed of 5 years ago. Or maybe, you have really lost the time to really file. So it depends. Now, further moving to section 10 and 11, the heart of which the examiner would love generally to ask, res judicata. Because that's a very good defense many a times we can take forward. Okay, we don't want to multiply the proceedings in the court. So res sub judice under section 10 is little different than res judicata. I will be highlighting those points right away. Res sub judice means stay of the suit under section 10, where no court shall proceed with the trial of any suit in which the matter in issue is also directly and substantially in issue in a previously instituted suit between the same parties or between the parties under whom they or any of them claim litigating under the same title. Please mark this word, same title, where such suit is pending in the same or any other court in India having jurisdiction to grant the relief claim, or in any other court beyond the limits of India established or constituted by the central government and having like jurisdiction or before the Supreme Court. See, now what is the object of section 10? I need to put that before you all, is to prevent the courts of concurrent jurisdiction from simultaneously trying two parallel suits between the same parties in respect of the same matter in issue. The section intends to prevent a person from multiplicity of proceedings and to avoid conflict of decisions. Now let us take an example. Like I have filed a suit in Bombay court against Mr. A and Mr. B. Now the same things, the property is situated in Bombay, another B is staying in Ahmedabad. So can I again proceed when my trial here in Bombay is on with the same remedies, same options in Ahmedabad court? The answer would be no, because you've already waiting here for trial, your matter is going on here. You'll say res sub judice point could be in considerations, and court would say this is multiplicity of proceedings, this is just some sheer harassment to the parties. Now, presence of two suits. What are the conditions which will be important? Presence of two suits. Where there are two suits, one previously instituted and the other subsequently instituted. Please mark this word subsequently instituted. It was already instituted earlier, like in Bombay, I had already instituted, then I subsequently go and file in Ahmedabad. And this sort of things would not be really a correct method to multiply the proceedings. So matter in issue. The matter in issue in subsequent suit must be directly and substantially in issue in the previous suit. So the same parties, that ingredient should be there. Both the suits must be between the same parties or between their representatives. Pendency of the suit, the previously instituted suit must be pending in the same court in which the subsequent suit is brought, or in any other court in India, or in any court beyond the limits of India established or empowered by the central government or before the Supreme Court. So the jurisdiction point of view, the court in which the previous suit is instituted must have jurisdiction to grant relief claimed in the subsequent suit. Same title, same parties, as I said, must be litigating under the same title in both the suits. So this is the nutshell of res sub judice. Now, how is res judicata differing from res sub judice? See, in section 10, the pendency of the suit is existing, and then I'm subsequently filing the other suit. But in section 11, it is quite different. Let's see what is the difference now. A case or a suit already decided. The rule of conclusiveness of the judgment is there. What is the meaning of res judicata? Consists of two Latin words. Res means a thing or a matter or a question, and judicata means adjudicated or decided. Therefore, the expression res judicata means a thing or a matter already decided. The court has already decided an issue between the parties who are same identical subject properties there. There's nothing new. And again, can I freshly file the same suit? Answer would be no. So let us see further. The principle of res judicata is based on the need of giving finality to the judicial decisions when a matter, whether on a question of fact or a question of law has been decided between two parties in one suit or proceeding, and decision is final, either because no appeal was taken to a higher court or because the appeal was dismissed or no appeal lies, neither party will be allowed in future or proceedings between the same parties to canvass the matter again. Because naturally, if I again and again with the same cause of action against the same parties keep filing repetitively the suit in the courts just to harass the party, the court will say this is absolutely not acceptable under the rule of the law under section 11 is absolutely hit by res judicata. So let us see the four maxims, which would be important when you quote your answers also. The doctrine of res judicata is based upon the following four maxims. Nemo deb lis vexeri pro una it edu causa. No man should be vexed twice for the same cause. Second one is interest republicable ut sit finis item. It is the interest of the state that there should be an end to a litigation. Nobody wants a litigation to go on and on and on and on the same subject matters. Hence, this maxim is important. Res judicata pro veritas occupitio. And judicial decision must be accepted as correct. And then res judicata pro veritas habetur. A judicated matter shall be deemed correct. So these four maxims are important, and two distinguishing points I would like to highlight here. What is a res judicata and res sub judice? How is it different? So I'm firstly going to point out what is res judicata. It applies to matter adjudicated upon res judicatum, whereas res sub judice, it applies to a matter pending the trial. I earlier also mentioned, I'm harping again and again on it, because this is the minor difference you need to know and how the sections are differing. Now, it bars the trial of a suit or an issue which has been decided in the former suit. This is res judicata, and res sub judice, it bars the trial of a suit which is pending decision in previously instituted suit. So this is the basic difference between the two. Now you'll ask me, what is issue of estoppel when I have to deal with res judicata? Let us understand that. There is a distinction between issue of estoppel and res judicata. Res judicata debars a court from exercising its jurisdiction to determine the list if it has attained finality between the parties, whereas the doctrine of issue of estoppel is invoked against the party. If such an issue is decided against him, he would be stopped from raising the same in the later proceedings. So again and again, if the issue is already decided against one particular party, he cannot repetitively say, no, this was not decided, this is what I want to take forward. Court will say, sorry, this is already decided and this is what you have already agreed for, and hence you cannot later on proceed further with it. So this is the difference between res judicata and issue of estoppel involved therein. Now, when a client comes to us with a case, look, I want to really go and sue Mr. B because Mr. B has done A, B, C, D and breached this particular thing and has destroyed my property. What is your question as a solicitor to ask? Okay, where was the property? Now, where does the party stay? Which court will have jurisdiction? So I'm going to deal with place of suing, and that would be how we can determine where we can advise our clients to sue, which is the best option for them. So section 15 to section 20 would be pertinent and important for us to deal with that angle of it. Because sometimes property is situated in Mumbai, parties are staying in Delhi, then we have business transactions happening in Kolkata, a lot of such different things happen. So which is the best court? On what basis do we decide? On pecuniary ground, territorial grounds, and so forth and so forth. We'll be seeing it. The first and the most important thing is the place of suing and order that a court can entertain, deal with, and decide the suit. Section 15 to 20 of CPC regulate the forum for the institution of the suits. Rules as to forum. The rules as to forum can be discussed under the following two heads. Rules as to pecuniary jurisdiction. The rule about the pecuniary jurisdiction is that every suit shall be instituted in the court of the lowest grade competent to try it. Rules as to nature of the suit. Suits may be divided into three classes. Suit in respect of immovable property, which deals with section 16 to 18. Suit for compensation for wrongful torts to person or movable property, section 19, and suits of the other kind, section 20. So when we divide this and when we actually read through the sections, we do get the feel of where we must advise our clients to actually sue. Because many a times with the wrong indications of advising them, oh, you can have Bombay as a jurisdiction. But actually, Bombay court can really not really decide the matter. Jurisdiction doesn't lie. This is a waste. It's a waste of time, waste of advice to the client. So let us see further. Suits to be instituted where subject matter is situated. Section 16 provides as subject to the pecuniary or other limitations prescribed by the law. So for partition of immovable property, for example, recovery without rent profits, these are the suits where we can decide on the pecuniary level of it. For foreclosure, sale or redemption in case of a mortgage or charge upon immovable property, for determination of any right or interest in immovable property. So there are many such things where the value, the pecuniary part of it is involved. More than 1 CR, we can go to high court, lesser than that, city civil court. So we need to decide what is actually the pecuniary part of it, and accordingly choose the divisions and decisions of where we must file our suits. Suits for immovable property situated within the jurisdiction of different courts. Now that is section 17, where a suit is to obtain relief respecting or compensation for wrong to immovable property situated within the jurisdiction of different courts. The suits may be instituted in any court within the local limits of whose jurisdiction any portion of the property is situated. That's important, provided that in respect of the value of the subject matter of the suit, the entire claim is cognizable by such court. So that's where you can choose, where the part of the property or any portion of the property is situated. If it's in Bombay, yes, Bombay, but jurisdiction, if you are filing in high court, the pecuniary level also and the value of the subject matter should also match it. So that's where it is. Place of institution of the suit where local limits of jurisdiction of the courts are uncertain. That's section 18, where it is alleged to be uncertain within the local limits of jurisdiction of which 2 or more courts, any immovable property is situated. Any of those courts may, if satisfied that there is ground for alleged uncertainty, record a statement to that effect and thereupon proceed to entertain and dispose of the suit relating to that property, and its decree in the suit shall have the same effect as if the property was situated within the local limits of the jurisdiction. So see, we have to be very careful when we are actually going to see where the jurisdiction is lying, because many a times you are not even certain whether we can go for this court in Bombay, or we can go in Delhi, or we can go in city civil court. We have to be very careful to see how the local limits of the jurisdictions can then be identified, even when there's uncertainty. So let's see this. Suits for compensation for wrong to person or movable property. That's under section 19, where a suit is for compensation for wrong done to the person or to movable property if the wrong was done within the local limits of the jurisdiction of one court, and the defendant resides or carries on business or personally works for gain within the local limits of the jurisdiction of another court. The suit may be instituted at the option of the plaintiff in either of the said courts. So illustration is very clear here, which will give you a clear picture of what I'm saying. A residing in Delhi meets B in Kolkata. B may sue A either in Kolkata or in Delhi, because that is the plaintiff's choice then, whether where the cause of action occurred there he should sue, or whether where he was residing he should sue. So that is completely the choice. Many a times with this sort of transactions happening, like I have signed a contract in Bombay and my partner is residing in Delhi, and a third person is staying in Bangalore, and the transaction is not really clarified. There's a breach there too. So if a person who wants to sue us, they'll have to make a choice. Should we sue the person in Bombay? Should we choose them where they are residing? So it's up to the plaintiff's choice then. Suits of the other kinds. Section 20, subject to the limitations aforesaid, every suit shall be instituted in a court within the local limits of whose jurisdiction the defendant or each defendant stays, and so forth and so forth. And cause of action or wholly where it's taking place. So illustration will be important. I'll just go to the illustration and you get a clear idea about what suits of the other kinds could be. A is a tradesman in Kolkata. B carries on business in Delhi. B, by his agent in Kolkata, buys goods of A and requests A to deliver them to East India Railway Company. A delivers the goods accordingly in Kolkata. A may sue B for the price of the goods, either in Kolkata where the cause of action has arisen, or in Delhi where B carries on his business. So this is what the entire jurisdiction point of view is, where we must select the jurisdiction point and where parties can sue. The choice would be on the plaintiff, and where, depending on where defendant resides, where the cause of action took place, and what is the value and the pecuniary levels of it. So let us see objections. How do you object this? Objections to jurisdiction, section 21. Objections as to territorial place of jurisdiction. No objection as to the place of suit shall be allowed by any appellate or revisional court unless such objection was taken in the first instance. At the very first instance, while we argue, when we feel that this court doesn't have the jurisdiction, we must raise it. Otherwise, what happens, my friends? Later stage, you feel like you want to take objections. Court will say you have not really taken the objections, though you already knew, and then you might lose this entertainment of your grievance about the territorial jurisdiction. So please take it on the first instance. That's very important, as we read in section 21. Then at the earliest possible opportunity, in all cases, the issues are settled at or before such settlement. And unless there has been consequent failure to the justice, obviously then later on you can say, we were not given an opportunity to be heard, therefore we are now taking this objections. But that is not a viable argument most of the times in practice. So all the three conditions must coexist. Now, bar of a fresh suit is section 21A. Bar on a suit to set aside decree on objection as to the place of suing. That's no suit shall lie challenging the validity of a decree passed in a formal suit between the same parties or between the parties under whom they or any of them claim litigating under the same title on any ground based on any objection as to the place of suing. Now, after knowing where we have to, really file our suits and what the jurisdiction point of it, I'm going to part two. Part two is pertaining to parties to the suit. Now, where do I know who will be the parties to my suit? How do I understand whether there's a non-joinder, misjoinder, which is a necessary party, proper party? I read that in Order 1, parties to the suit. Order 1 of the court provides the provisions with respect to the parties to the suits and joinder, misjoinder, and non-joinder of the parties. Now, what is the joinder of the parties? And there are more than one plaintiffs or more than one defendants. It's basically is used there. Joinder of the plaintiff, Rule 1. Joinder of the defendant, Rule 3. That's of Order 1, what I'm reading, yeah. The question of joinder of the parties arises only when an act is done by two or more persons, joinder of the defendants, or in affects two or more persons, joinder of the plaintiffs. So joinder of the plaintiffs, Rule 1, all persons may be joined in one suit as plaintiffs where any right to relief in respect of arising out of the same act or transaction or series of the acts or transactions is alleged to exist in such persons, whether jointly or severally alternatively. So basically, one needs to know if there is one plaintiff, then there is no problem. But if there are more, then we have to know whether they, all legal heirs, for example, will be parties to it. Do we have to add them as, defendants? Whether we have to add them as plaintiffs, we need to decide that accordingly. So it depends on case to case. So while you decide, you have to see the rule in this Order 1. And if such persons brought separate suits, any common question of law is, required to be dealt with, then you need to understand that, yes, these plaintiffs altogether must be joined, or these defendants, we are going to sue against them. They all are necessary parties. They all are important to be added. So accordingly, when we get the transactions and cases in the hand, we need to see. We can't miss out relevant parties because they would be necessary for the entire litigation's outcome. They would be having their stake. We can't miss out parties who would be proper parties to it, because many times they would be essential components to get us evidence also. We would have to analyze all of it, and hence we have to study who is essential to be joined as a party. And this is very critical. Many times we miss out the points that, okay, we have not added Mr. B as the party, though he was a relevant party, a necessary party. So I will run to that also. All persons may be joined in one suit as defendants, where any right to relief in respect of arising out of the same act or transaction or series of the acts of transaction is alleged to exist against such persons, whether jointly or severally. So in separate suits were brought against each person, any common question of law would arise, then obviously you'll have to add them as the party. Now, how would the judgment turn out to be? Judgment for or against one or more joint parties would be, the court may give judgment for one or more the plaintiffs as may be found to entitle the relief, as against one or more defendants as may be found to be liable. So obviously it won't be independently then. Once you join them, it will be a common judgment for and against both. Now, what is a necessary and proper parties? Very, very important. Because if you don't know who's a necessary party to your proceedings, it's a failure for you to even file the suit. For example, in a landlord tenancy matters, can I drop out co-tenant to be the party along? Obviously, no. The co-tenant with the tenant will also be the necessary parties. But what about the landlord's caretaker? I mean, there are sometimes landlord's caretakers. Should they also be parties as a necessary party who will have to file the suit? Answer is no, not required. Landlords are enough to file the suit if they are for the plaintiffs. So we need to understand whether there would be proper parties, necessary parties. Let's see what the difference of that is also highlighted. A necessary party is one whose presence is indispensable in the constitution of the suit, against whom the relief is sought, and without whom no effective order can be made. As I said, if you're going to miss out the co-tenant whose rights are there in this particular property, which the landlord has given him as on tenancy, will I be able to really suffice against one co-tenant and dropping out the second co-tenant? Answer is no. You'll have to add both of them, because both the rights as tenancy was there with mine as a landlord. So we need to understand this and see whether the party without whom it is indispensable for the justice, for the suit to be disposed of, if it's dropped out, will there be any effectiveness in the suit? Answer would be negative. Necessary parties have to be joined. In the absence of a necessary party, no decree can be passed, while a proper party is one in whose absence an effective order can be made, but whose presence is required for a complete and all decisions on the question involved in proceedings. In absence of a proper party, a decree can be passed so far as it relates to the parties in this suit. Now I'm giving you an example. Please hear my example clearly. We'll get a clear picture of it. Example, in a petition for compensation in a road accident case, the claimants may join three parties: owner of the vehicles involved in the accident, insurers, and the insurer of the vehicles, and the driver of the vehicle as respondents. The owner and the insurance, if any, are the necessary parties along with the claimants, while the drivers of the vehicles involved is a formal or proper party, which presence enables the court to adjudicate more effectively and completely. But even in the absence of this, a decree can be passed. So here we see the example. This driver was not really a necessary party, but a proper party who would be useful to get an effective conclusion to the court. But if I drop out the driver to be the party here, still I can get a decree in this case by analyzing the vehicle owner and the insurance holder. So this is how we need to understand who would be necessary and proper party. Sometimes we need to add, in many matters in my day-to-day practice, we see this planning authorities as formal parties. For example, I'm suing a suit against a corporation, but even planning authority could be MADA. So I have to add them as a party, as a proper party sometimes, maybe not a necessary party, because they have interstate connectivity many a time. So example, I'm just giving a hypothetical example. It would be essential for me to add even MADA as a party or SRA as a party, depending on whether it's a proper method to get an effective conclusion of what data corporation would give me if I'm suing against them. So it would help the court analyze. So we need to understand accordingly and make proper parties to the proceedings and necessary parties. Don't drop out necessary parties, because without them, you will really not get any conclusive decisions. Non-joinder or misjoinder of the parties. Now, what is that? Non-joinder means not joining proper or necessary parties to the suit, while misjoinder is a state of joining two or more persons, whether necessary or proper parties, as plaintiffs or defendants on one suit in contravention with Rules 1 and Rule 3 respectively. So as a general rule, a suit shall not be dismissed only on the ground of non-joinder or misjoinder of the parties, except in case of non-joinder or necessary parties. Now, how do you take objections as to non-joinder or misjoinder of the parties? As has been provided in Rule 13 of Order 1, all objections on the grounds of non-joinder or misjoinder of the parties shall be taken at the earliest possible way. Naturally, you have to take it early, because in the later stage, you cannot really say, I have objections to this. The court will say, you had the opportunity to highlight this before us and indicate to us that this is what the flaw is, the non-joinder or misjoinder of the party. This person shouldn't have been party to it, but he's added. So it's a misjoinder. So it happens many a times when we see in huge matters and litigations, unnecessary legal heads are added who are not even related to the property. Even the far distinct relatives are added. So court would say, this is a misjoinder. This person has got nothing to do with the property. Let's delete them out. So this way we can get the order, striking it out. So there is also suit in the nature of wrong parties. Order 1, Rule 10 deals with cases where striking out, addition or substitution of the parties. It could be sometimes adding in new parties also, where it would be necessary in the subsequent stage. You see, without this person, the further hearing of the matter would not be very feasibly correct. So court would say, okay, then in that case, you add this person as a party. He will be able to give us more data, more information, and we can come to a conclusive justice for that. So it depends. It's again case to case. Now, the very important answer which I would see from examination point of view would be representative suit. Order 1, Rule 8. So when I say, please study this from the examination point of view, doesn't mean it's coming in the exam. I'm not indicating that. What I'm trying to say, it's essential for us to know What is a representative suit? Because many a times we need to represent for a lot of people together, and we don't know how many people to be made as a party. It's not necessary that you have to make every members of the party in a society if you're filing a society a suit against them. So a secretary or managing person who can represent all of them would be good enough. So we need to know the thumb rule of order 1 rule 8 for this. Order 8 rule 1 is yeah. So what is it? It's order 1 rule 8 is an exception to the general rule that all persons interested in the suit ought to be joined as the parties to it in order to finally adjudicate all matters involved therein and to avoid the fresh litigations over the same matters. So representative suit may be defined as a representative suit, a suit filed by or against one or more persons on behalf of themselves and others having the same interest in the suit. So this is something you need to know. And there can be multiple examples of a public trust, of an institution. They're representing many people, but not all of them can be necessarily made independent parties. So to represent all of them together, it's fine if an institution represents. It's fine if an NGO represents. So depending on that, this representative suit, because whatever the outcome comes of the decision, it will be applicable for all those members also who are part of that NGO, who are trustees of the NGO, and who are stakeholders of these institutions. So now we go to frame of the suit. Order 2. Now how do you frame the suit? Order 2 of the code deals with the provisions relating to framing of the suit and rules regarding cause of actions. A cause of action means every fact which is necessary for the plaintiff to establish to support his claim in obtaining judgment in his favor. Order 2 rule 1 explains that every suit shall be framed so as to afford ground for final decision upon the subject in disputes and to prevent further litigations concerning them. Now, suit to include the whole claim would fall into the rule 2 of order 2, which is based upon the principle that the defendant should not be vexed twice for the same cause of action. What is the sub rule 2 of the rule is important here. Order 2 provides that every suit shall include the whole claim in respect of the cause of action. But relinquishment of the claim is also possible. But a plaintiff may relinquish any portion of his claim in order to bring the suit within the jurisdiction of the court, and where a person is entitled to more than one relief in respect of the same cause of action, then he may sue for all or any of such relief. It depends on the plaintiff. Then he can say, okay, I don't want to involve my second company in this particular claim. I want to leave it aside, so I'm relinquishing that right over it. So it's fine. It's a plaintiff's choice. Then he may relinquish that portion of that company which he didn't want to involve with the entire company's estates that he was holding here. So that depends on the decisions of the plaintiff who's making the plaint here. So let us see now order 6, pleadings. Now what is a pleading? See, before we go to the pleading, I must put 3 important things together. While we study pleadings, we must keep 2 additional books with us. First, High Court original side book. We must know our rules together. As and when we're reading the pleadings, we must also turn to the rules and see what the procedural part of it in filing processes. Because many a times the theory given in the CPC would not be suffice for you to practically go and look forward in the departments of how we can really file the plaint, how we can really file the written statements. You need to have your rules handy. Second, which I said, is drafting. When I say pleading is not the theory. The theory would conclude the creativity of how you want to put your plaint, how you want to put your written statements. So it covers the entire organ of drafting as well as the organ of the rules and also the theory part of it. So without that, please do not study. You have to keep all these 3 things together. And I will obviously give some points while I describe and explain you what pleading really would involve. So I will also teach you, or rather put forward, of how you can draft prayers in a plaint and what consists of written statements. So when I go forward in the subject wise, we will be touching all those points. So pleading order 6. According to order 6, rule 1, pleading shall mean plaint or written statement. Pleadings are statements in writing, drawn up and filed by each party to a case, stating what his contentions will be as the trial and giving all such details to his opponents needs to know in order to prepare his case and answer. In proceedings before a civil court, pleading may include a petition and reply to the respondent, whether to form an affidavit or whether to form an application's answer. It depends on that. Plaintiff's pleading is called the plaint, while the defendant's pleading is called the written statement. Now, as a whole, the entire law governing the pleading is contained in the provisions of Order 6, that's pleading, Order 7, plaint, Order 8, written statement of the court. And apart from this, some important fundamental procedural matters relating to the practice are the provisions of Order 1, parties to the suit, as the manner in which the suit should be framed, Order 2, frame of the suit, and as to who should sign the pleading, Order 3, and Order 4, institution of the suit, and to taking out summons and service thereto. So this entire process would be in it. Fundamental rules of pleading, the general rule which I'll be sharing here is pleading must state the facts and not the law. Only and not the law, and only the material facts must be stated. Pleading should not include the evidence, and the facts stated must be in a concise form. It should not be vague. It should be very consistent. It should be very factual, and it should not be like, okay, this could have been there, let's add it here. This is it, that's why I'm adding it here. It should be that precise. So material facts, the facts are of two types. The facts probenda, the facts required to be proved, material facts, and the facts probentia, the facts by means of which they are to be proved, that is particulars of evidence. And of course, many a times you need to amend the pleadings also with leave of the court. So amendment of the pleading, Order 6, Rule 17 is also there. As a general rule, material facts and necessary particulars must be stated in the pleadings, and the decisions cannot be based on the ground outside the pleadings. But due to various reasons, parties have amended the plaints. Maybe at a later stage, they got to know some more things which were factually not present at that particular time when they filed the plea. So with the leave of it, court may allow them. So it's again the discretion of the court whether court would find it necessary, depending on this, the defendant's rights should not be prejudiced. So this is how even amendments are permitted. And many a times we do find that these amendment applications are there, and the entire arguments of what we had proceeded as the plaintiff would slightly then additionally change also, because amendments have brought in new facts sometimes. So that's again on the matter of the court, and each case it would differ. But amendments would be essential. Permission to amend when granted. A leave to amend the pleading will be granted by the court, whereby the amendment, no injury will be caused to the opposite party, and he can be sufficiently compensated by cost or other terms to be imposed by the order, and where the amendment is necessary for determination of a real question in controversy, and no injustice will be caused to other party, the court may allow the amendment to the pleadings. Now, this is the outline of what we understand what pleadings would cover. Now, specifically, I would deal with plaint. Now, Order 7, introduction of the plaint would be, every civil suit shall be instituted by presenting a plaint to the court or such officer as it appoints in that behalf. Plaint is a pleading of the plaintiff. Meaning, let me tell you, in the entire code, the definition of plaint is not given. The word has not been defined in the code, but it is said to be statement of claim, a document by presentation of which the suit is instituted. So what does a plaint consist? As I said, I'll be giving you guidance on how to draft it. The title of the suit, the body of the plaint, then the relief prayed thereto, then what it would consist of. Title of the suit consists of the name of the court, case number to be given by the office of the court, and descriptions of the parties. So you need to clearly write which court it is. Then you need to write where the parties are staying, where the residence address is, where the office address is, if at all you're using that. So it has to be very specific in the title. Then the body of the plaint, in the part, the plaint consists of the facts constituting the cause of action and when it arose. So plaint's body would deal with cause of actions, when it arose and how it arose. The descriptive part of it would be the body of the plaint, then reliefs. The relief shall finally contain the relief which the plaintiff claims, either simply or in the end. Every plaint shall state specifically the relief which the plaintiff claims, either simply or in alternative. Generally, plaintiff is not entitled to relief for which there is no foundation in the plaint, except in a case where no pleadings, issues, and evidence, the relief is clear, because primary duty of the court is to do justice. So basically, what is pleaded, on that basis, you need to put your prayers, and only on that basis the court can decide. Beyond the pleadings, only when there are rare chances that, if I don't go beyond the pleading, I cannot do justice, the judge may take forward for it. Otherwise, only it's covered in the four corners of the pleadings, generally. So pleadings ought to be given such relief as he is entitled to. Therefore, the plaintiff has to put about those relief which he knows he can get from the court. And he must put that in his prayers very specifically. Then the equitable relief under Order 7, Rule 7 may be granted even though grounds on which the relief is sought not to be stated, as required by the rule, if at all. So particulars of the plaint, as I said, would consist the name of the court, descriptions of the place, residence, description of the place, residence far, where is he staying, what kind of business he was doing, who is he, and so forth. Where the plaintiff or the defendant is minor, the person of the unsound mind stated, the guardians would be the part of it. Then the facts constituting the cause of action when it arose, and the facts showing that the court has jurisdiction, that needs to be written down in the plaint, and the relief which the plaintiff claims. Where the plaintiff has allowed a set off or relinquished a portion of his claim, the amount so allowed or relinquished needs to be specified. A statement of the value of the subject matter of the suit for the purpose of jurisdiction and of the court fees, as far as it admits, it needs to be mentioned very clearly in the plaint. So these are the ingredients. And while you draft it, you need to put through all this. Later stage, it becomes very difficult to amend it, and also my advice would be there, yes, while you draft, be perfect therein. In case of recovery suit, the precise amount claimed or where it is for the accounts of means profit of a movable possessions of the defendant or the debts thereon, which cannot be determined. Approximate amount can be put in. That's fine. Then description of immovable property needs to be detailedly scheduled out and given in the plaint. The interest and liability of the defendant needs to be put in. Then if the suit is filed in the representative character, it must state the fact about the actual existing interest of the plaintiff in subject matter, and that all steps necessary has been taken by him to institute the suit. The grounds upon which such exemptions from the law of limitation, that the suit is not time barred, that also you need to put in. Now, when I read plaint, now we also see in Order 7, Rule 10, return of the plaint. Now, what is that? The plaint shall at any stage of the suit be returned to be presented in the court in which it shall have been instituted. Explanation for the removal of doubts, it is hereby declared that a court of appeal or revision may direct, after setting aside the decree suit in a suit, to return the plaint under this rule. Then procedure on returning the plaint could be, on returning the plaint, the judge shall endorse thereon the date of its presentation and return the name of the party representing it and brief statement of the reasons for returning it. So many times the plaints are returned, and it generally happens when there is some technical defect seen. Okay. Listen, we are returning the plaint. Kindly, finish the technical defects of it, and you can again come back. Now, what is rejection of plaint? That is different than what is return of the plaint. Order 7, Rule 11 deals with rejection of the plaint. Now, the plaint shall be rejected on following cases. I'll go slow here because it's important for you to know. Where it does not disclose cause of action, where the relief claimed is undervalued and the plaintiff, on being required by the court to correct the valuation within the time is to be fixed by the court, fails to do so, where the relief claimed is properly valued but the plaintiff is written upon paper insufficiently stamped, and the plaintiff, on being required by the court to supply the requisite stamp paper within the time to be fixed and fails to do so, where the suit appears from the statement in the plaint to be barred by any law, and where it is not filed in duplicate, and where the plaintiff fails to comply with the provisions of Rule 9. So this was what I'm dealing about, is how and when the plaints can be rejected. So moving forward with High Court original side rules, you need to see Rule 42 and 59 of Chapter 4, which was there in my book. I don't know which the chapter would be there in your book. I believe it would be Chapter 4, though. See, now what the plaint should consist. There is a format, and that format which is specified in the High Court rules, the plaint has to be presented in that format. There has to be annexures of documents, exhibits thereto. There has to be copies, language which is prescribed in the High Court rules book. We need to follow that and accordingly prepare the plaint. Documents, list of documents, index. It starts with index, plaint, wakalatnama, memorandum of registered address, list of documents, exhibits, copies, and all. We need to annex everything together before we file. Then also the court fees which we need to pay. All that procedures are given. And every alteration, interlation, whichever is to be made, it's all given in the High Court rules. And simultaneously, while you study your pleadings and while you study the portion of the plaint, keep your High Court book open. So you will know which provisions would be really appropriate to add. Because many a times, the syllabus is really vast. It's not necessary for you to really study each and everything, but do study. But you know, this is relevant, and in this answer, I can adjust these rules and I can write my answer. So that really would cream out your whole layer of what plaint is and what rules would be relevant. Like particulars of the claim annexed to the plaint would be also important. Then plaint to be verified and before whom. We have all these rules and how the lodging and presentation is done. So it gives you the satisfaction when you study that, yes, now I know complete filing process. In practical sense, I would advise, do move around in departments with your High Court original site clerks. They would actually show you the method. And then when you correlate your rules, you'll be comfortable. Yes, this is so simple in the chronology, which I've practically done. So form of appearance is wakalatnama. We all know how it is. And all these things need to be presented, which is mentioned specifically in the High Court original site rules. Now, party represented by the advocate, not entitled. Party has to appear in person. What are the rules to be followed? We have it all. So go through it. I'm not wasting time over reading it here. It's very simple. So I'll move forward to written statements now. What is a written statement? It's a defense. Now let us see that. A written statement is a pleading of the defendant for submission of every material fact to answer the allegations made by the plaintiff in his plaint. The word has not been defined in the code. As usual, what is WS? We do not have a clear-cut definition in the code. But to understand, a written statement is pleading of defendant, wherein he deals with every material fact alleged by the plaintiff in his plaint and also states any new facts in his favor or takes legal objections against the claim in the plaintiff. So naturally, I mean, once I'm suing somebody and I'm saying A, B, C, D things are my facts, the defendant has his facts to put forward. He has his denials, his admissions, and his additional facts which he wants to put forward. So all these things, he gets it down and prepares a written statement based on the plaintiff's plaint and also additional information which he wants to put in. Now we will see all relevant rules for preparation of a rule applied to WS if it should be prepared with a great caution. In written statement, firstly, the defendant should mention the name of the court trying the suit, then the names of the parties and where they reside. It is not necessary to mention the names, directions, place of the residence of all the parties in the title of the written statement, but mentioning the name of the first plaintiff, first defendant is enough. So that's a short title basically. The number of suit may be mentioned thereafter. The defendant thereupon replies on each para. Para-wise is better to be replied of the plaint, except where any preliminary objection like maintainability of the suit, locus standi of the plaint to file the suit, the non-joinder or misjoinder of the parties as to jurisdiction of the court or as to limitation has been raised. For consideration which is necessary is to first issue it on merits itself. So there are particular rules of defense which we should know, because if you really don't know how to defend and put your materials which are relevant as against what you have seen in the plaint, it will be very difficult for you to at a later stage file additional written statements. So what you have today, the rules of defense must be first incorporated in a right method. So let us see those. The denial in a written statement must be specific and not general. Okay, it has to be specific, A, and A, it cannot be, it should be A to Z. Okay. So let us see how it goes. The grounds alleged by the plaintiff must be denied by a defendant specifically with each allegation of fact of which he does not admit the truth except damages. Then the denial should not be vague. Like we said, the plaint also should not be vague. Every allegations of the fact in the plaint is not denied specifically or by necessary implication or stated by not admitted in the pleading of the defendant shall be taken to be admitted except as regards persons of disability. Let's not go there. In cases where the defendant has not filed a pleading, it shall be lawful for the court to pronounce judgment on the basis of the facts in the plaint, except as against the persons under disability by the court in its discretion, and may require any fact to be proved. Now, whenever a judgment is pronounced under Rule 2, a decree shall be drawn upon in accordance with such judgment. Now, what is the time factor? It's very important. Can I file a WS after like 6-7 months? No, there is a time maintainability here. Defendant shall file his written statement of his defense within 30 days from the date of the service of summons to him, but about time may be extended by the court for the period and shall not be later than 90 days from the date of its service of summons. Now, extension of time for presenting the written statements ordinary would be scheduled as prescribed under Order 8, Rule 1, which has to be honored. The extension of the time sought to be, by the defendant from the court, whether within 30 days or 90 days, as the case may be, but should not be granted just as a matter of routine and merely for asking more when the period of 90 days is expired. Obviously, otherwise, if people will go on with their own gala time to file written statement, there will be never further progress in this. So matter has to have this deadlines and this days which we need to consider and be very tactful about while we file our written statements. So subsequent pleading, Order 8, Rule 9, no pleading subsequent to the written statement of the defendant other than by way of defense or set off or counterclaim shall be presented except by leave of the court. The court may at any time require WS or additional WS from any parties and fixed time not more than 30 days for presenting the same. Now, failure to written statement, what happens? To present the written statement, what happens? When a party fails to file a written statement as required under Rule 1 or Rule 9 within a time permitted or fixed by the court shall pronounce judgment against him as or make such order as it deems fit, or such judgment as a decree shall be drawn upon. The provisions regarding duty of the defendant to produce documents upon which relief is claimed or relied upon by him have been given under Order 8, Rule 1A. So now what is a set-off would be important for me to highlight in this lecture. Set-off under Order 8, Rule 6 would be important because plaintiff is saying, I ought to take 50 lakhs from Mr. B, for example. Mr. B is saying, I also ought to take something like 50 lakhs from Mr. A. So in his written statement, he said this has to be set off. Let us see the definitions of it in a detailed way to understand it. A set-off means a claim set up against another. It is a counterclaim against the plaintiff, but in essence, it is a form of defense in which the defendant will acknowledge that the justice of the plaintiff's claim sets up a demand of his own to counterbalance it either in a whole or in part. It could be lesser, it could be in part. So it depends of what his recovery also lies from the plaintiff. So let us see this. The doctrine of set-off included in Order 8, Rule 6 and is as under, where in a suit for recovery, the money of the defendant claims to set off against the plaintiff's demand any a certain amount of money legally recoverable by him from the plaintiff, not exceeding the pecuniary limits. Please understand, not exceeding the pecuniary limits of the jurisdiction of the court. And both parties file the same and they fill in the same characters as they would fill as a plaintiff of the suit that even I ought to recover from him.
Hello. आज
is counterclaims. In a form of suit, it can be taken forward. Exclusion of the counterclaim, where a defendant sets up a counterclaim and the plaintiff contends that the claim thereby raised ought not to be disposed of by way of counterclaim, but it is an independent suit. The plaintiff may, at the time before issues are settled in relation to the counterclaim, apply to the court, which may, on the hearing of such an application, make such an order as it thinks deemed fit. Now, effect of discontinuations of suit we need not do, but I'll just give a touch up of it. If in any case in which the defendant sets up a counterclaim, the suit of the plaintiff is stayed, discontinued, or dismissed, the counterclaim may nevertheless be proceeded with. So it's obviously the way the suit is proceeding, if the counterclaim would proceed. Now, Rule 6E is default of the plaintiff to reply to the counterclaim. If the plaintiff makes a default in putting in a reply to the counterclaim made by the defendant, the court may pronounce judgment against the plaintiff in relation to counterclaim made against him, or make such order in relation to the counterclaim as it deems fit. So while you write your answers about what the pleadings would be, please cover plaint, written statement, set off, counterclaim, and give these rules in a brief summary form. Because this will give us an indication that yes, the pleadings would also include counterclaims, set off many a times, and we should not be missing out the procedural part of it, because if we do in the later stage, it gets very difficult to get it incorporated. So rules relating to written statement also apply. The rules relating to written statement by defendant shall apply as to answer a counterclaim. Then defense or set off or a counterclaim founded upon separate grounds, where the defendant relies upon several distinct grounds of defense or set off or counterclaim. The claim would be found upon the separate and distinct fact. They shall be stated as far as separately and distinctly. So we should have this entire bifurcation very clearly and in a clear concept when we are studying our WS also. Because written statement would just not be as simple as it's pleaded like in pleading of a plaint, because written statement would also, I would have to know whether the defendant has any other claims pertaining to the plaint, pertaining against more of what the plaintiff is claiming. So all that things should be considered and accordingly made effective in a pleading format, in a written statement, set off, or counterclaim at the earliest stage. That is a key point. Okay. Now, what are the rules of the OS side for WS set off and counterclaims? It would be in Chapter 7, Original Side Rules Book, Rule 88 to 104. As I said while I was reading and explaining about WS, the time factor is very important. The time of filing, the appearance, and the wakalatnama of the defendant would also be important in Rule 88, which clarifies and shows that within how many days or how many weeks you need to file. So let's go through. This rule is important, so I want to read through. In suits where the WS is called by the writ of summons, the defendant shall file an appearance in person or wakalatnama as the case may be within 12 weeks from the service of the writ of summons. Then in matrimonial suits, the defendant shall file appearance in person or wakalatnama as the case may be before the date fixed. And in summary suits, it will generally be within 10 days from the service of the writ of summons. So now what happens if there is a default in filing of the wakalatnama? All that procedures are given in the rules. So kindly go through them and also put in your answers if they ask what is the entire rules when it comes to filing of a WS or presenting of a WS. So you should know them very clearly. Then about set off by the defendant, Rule 93, I will just like to go through that rule. A defendant in a suit for a recovery of money in addition to his right of pleading of a set off allowed under Order 8 Rule 6 of the Code of the Civil Procedure may set off a claim for damages provided it arises out of the same transaction as the transaction in the suit. So this rule we need to see, and judge may allow and disallow. It's upon the judge. Under Rule 94, the judge may, on application of the plaintiff at any stage of the proceedings in the suit, if in open cannot be conveniently disposed of in pending action or ought not to be allowed, refuse permission to the defendant to avail himself thereof and require him to file a separate suit. So once we see these rules, we get a clear picture of how entire practicality, departmental work and proceedings need to be filed on time, because we can't go on delaying the process, and hence this rules will be important for us from the examination point of view also. Claim against person and not party. We all have all these rules. Rule 98 is also important. Go through that. Then reply to the counterclaim is important under Rule 100. A defendant to the counterclaim shall file his appearance in person or wakalatnama and reply to the counterclaim within 8 weeks from the service of the written statement and counterclaim upon. So this days would be important and this time period would be important for you to remember. The rest all would be very, very procedural and very simple. So in a day-to-day working, if you are actually going to the department with your oversight clerks, you will definitely know all this, and it will be very easy for you to write in your answers. It's not that difficult. Now we will go to summons and discovery and issue of summons under section 27 to 29, which is the part 3 of my lecture. So I'll be touching those importantly now. An intimation sent to the defendant witness by the court to the defendant, order 5, and to the witness, order 16. Please correlate those orders. You need to write it very clearly. So what is the meaning of a summons? Again, it's not defined in the code, but according to the dictionary meaning, we should know a summons is a document issued from the office of the court of justice calling upon the person to whom it is directed to attend before a judge or office of the court for a certain purpose. See, this is very important because many a times the witness will say, I'm not ready to come to the court. There'll be summons issued. You'll have to come. The courts can issue that. So many a times defendants would refuse to take, the acceptance of the plaint and deliveries of the same. Even if you do RPAD, then sometimes the summons would need to be called forward for. So let's see what it is. The summons must contain direction whether the date fixed is for settlement of the issue or for the final disposal of the suit under Rule 5. In case of summons for final disposal of the suit, the defendant shall be directed to produce its witness as per Rule 8. Then the court must give sufficient time to defendant to enable him to appear and answer the claim of the plaintiff on the day fixed as per the Rule 6. So summons shall contain an order to the defendant to produce all documents in his possession or power upon which he intends to rely on in support of his case as per Rule 7. So this is how we need to understand what are the rules in respect to the summons, and also the provisions, that section now which I'm going to read through. Summons to defendant, section 27, where a suit has been duly instituted, a summons may be issued to the defendant to appear and answer the claim, and may be served in the manner prescribed on such date, not beyond 30 days from the date of the institution of the plaint. So section 27 is very clear, and the time frame is given within how much day they have to do through it. It's 30 days. Order 5, Rule 1. When a suit has been instituted, a summons may be issued to the defendant to appear and answer the claim and to file the written statement of his defense, if any, within 30 days from the date of the service of the summons to the defendants. This is very precisely incorporated so that there's no delay and the time limits are followed properly, because everybody knows that the procedural law shows how exactly one has to present not only the plaintiff, defendant, even witnesses and third parties sometimes who are involved there too. So we definitely have to have time frame fixed in, which are very well fixed in here, and on that basis, understanding the concepts of this, we need to present summons within how much day, after that what we need to do, and how the appearance happens. So I'm going to read through appearance of defendant now. Order 5, Rule 1 and Sub-Rule 2. Defendant to whom a summons has been issued under Sub-Rule 1 may appear in person by a pleader duly instructed or able to answer all material questions relating to the suit, or by a pleader accompanied by some person able to answer all such questions. The court, however, may order the defendant or the plaintiff to appear in person. So it's very clear, like you have to know, you have to be prepared. This is the plaint, this is the copy, and you got to know what your answers are and why are you called for. So everything is very crystal clear mentioned, and defendant has to come ready when he comes in person to appear, or whether he comes with a lawyer or he comes with a pleader. So it's quite important for them to know what reasons they've come, and hence the details of it needs to be incorporated well. Every such summons shall be signed by the judge or the officer which is appointed by the judge, and shall be sealed in the court seal cover. Exemption from personal appearances is under Order 5, Rule 4. No party shall be ordered to appear in person unless he resides within the local limits of the court's ordinary original jurisdiction, or without such limits, but at a place less than 50, or these are all technical like problems, so you all can read through it, or where there is a railway or steamer communication or other established public conveyance for 5th, 6th distance between the place where he resides. So don't go into these details of this information, but he should be within the local jurisdiction, that's fine, or within less than 200 miles, put it to that. Who is a woman not appearing in person, and who's entitled to exemption under this code. So no party shall be appearing unless these provisions are added through and they're exempted. So we have seen who are exempted, and under jurisdiction they should fall in, so they can be called upon to appear in person. So mode of service of summons. Now, how are the summons should be served? Service of summons shall be made by delivering or tendering a copy thereof signed by the judge or such officer as he appoints in his behalf and sealed with the seal of the court. The court prescribes four principal modes of serving. This is important, and I think you all should know it more in details, particularly substitution of service, which I will read. Personal or direct service, substituted service, then service by the court and service by the plaintiff. Now, personal or direct service, this is an ordinary mode of service or summons. And under the following categories, a service of summons should be made by delivery of or tendering a copy thereof to the defendant personally or his agents or other person on his behalf. For the proper service of the summons, following principles must be remembered. Where there are two or more defendants, service should be made to each defendant. You cannot say, oh, I've already served to one defendant. Why should I serve to others? No, each and every defendant needs to be served. Then where it is practical, the summons must be served to the defendant in person or his authorized agent. Then in suit relating to any business or work against the person not residing within the territorial jurisdiction of the court issuing the summons, it may be served to the manager or the agent who is carrying on the business of the work thereto. In a suit for immovable property, if the service of the summons cannot be made on the defendant personally, then the defendant has no authorized agent. For example, the service may be made to any agent of the defendant in charge of the property. So where the defendant is absent from his residence at the time of the service of the summons, there is no likelihood for him to be found. Then within a reasonable time, if no authorized person is found, then any male, adult or female member of his family members can be given. So I'm not getting into too details of it. You should know how it should be served. But importantly, you should know if the defendant is not found, what do you do then? A substituted service method should be applied. So means the service of summons by a mode which is substituted for the ordinary mode of summons. The circumstances for substituted service are, and this is important from the examination point of view, hence you should hear me carefully. Where the defendant or his agent refuse to sign or acknowledge the summons, then where the serving officer, after due and reasonable diligence, cannot find the defendant who is absent from his residence at the time when the service is sought to be effected on him at his residence, and there is no likelihood of him being found at his residence within a reasonable time, and there is no authorized agent or any person found to whom the service can be made, the serving officer shall affix a copy of the summons on the outdoor or some other conspicuous part of the house in which the defendant ordinarily resides or carries on his business or personally works for the claims. So this is a substituted method of sticking basically the notice or the summons, a process, house or nearby area of it, which is visible for him. Because why do they say nearby the house? Because we know somewhere or the other he would come, he would at least have a notice of it if it's not given handily to him. Then the serving officer shall then return the original to the court from which it was issued with a report endorsed thereon or annexed thereto, stating the fact about affixing the copy, the circumstances under which they did so, and the whole report is given to the court accordingly. If the court is satisfied, you would say, yes, this was a perfect service and it's fine there too. The second mode, as provided by the Rule 17, the declaration by the court about the due service of the summons is essential. If the provisions of Rule 19 have not been complied with, the service of the summons cannot be said to be in accordance with law. Now, where the court is satisfied that there is a reason to believe that the defendant is avoiding the service, it happens many a times in our day-to-day activity when we have to serve. Defendant is purposely and deliberately not refusing. Then what does the court do? See, this is the answer for this. Or for any other reason, summons cannot be served in the ordinary way, the court shall order the service may be affected in the following manner. And the manner is as under, which I'm just showing right away. By affixing the copy of the summons in some conspicuous part of the house, as we have said earlier, also upon the conspicuous part of the house in which the defendant is known to have last resided, carried on the business, or personally worked for gain, in such manner as the court thinks fit, as per the deemed rules. By advertisement in the daily newspaper, circulating in the locality in which the defendant is last known to have, stayed. So this is how the attempts are made that defendant should know that, look, this plaint is filed, this is the summons and you ought to come to the court. So this is the methods which the rules have it, and the order is very clear. And when we write our answers, we should cover this entire, rules and sub-rules in a clear crystal language, that if summons are not duly served, what does the court do? How is it to be done substitutedly? So that will cover your answer of serving of the summons. Now, substituted service under Rule 20 is as effective as personal service. That is clear. So you should know the Rule 20, Sub Rule 2. Now, declaration by the court and all we know, we've already seen it. So I'm not going by it. But once the service is made, a proper affidavit can also be filed that the summons are served and it's accepted sometimes in the court. Now, what is discovery? Section 30 and Order 11, we need to read that together. Section 30 of the code says that subject to such conditions and limitations as may be prescribed, the court may at any time of its own motion on application of any party make such orders as may be necessary and reasonable for relating to the delivery of answers, interrogatories, the admissions of the documents, facts and discovery of inspection, productions, impounding, return of documents and material objects, and producible as evidence. So this is something you should just know, because many a times we need to inspect the documents, we need to go forward for some detailed information. So this rules really play an important role at that time, and this provisions in section which 30 VFC would be important. Now, summoning and attendance of witness under section 31 and order 26. So this is quite often used. So I must analyze and put it forward before you all. According to section 31, provisions in section 27, 28, and 29 shall apply to summons to give evidence or to produce documents or other material objects. Rule 8 of order 20, order rule 8 of order 51 states that summons under order 51 except the rule 7A shall be served in same manner as the summons to the defendants. So let's not get into all these details, but we should know how summons to the witness can be given. Attendance of the witness would be important on or before such date, which may be fixed by the court and shall not be later than 15 days from the date on which the issues are settled. A list of proposed witnesses to give evidence or to produce document and obtain summons to such persons for their attendance in court shall be presented by the court in the parties. So this is how the summons need to be given forward, and we need to take it with that understanding that witness cannot directly come with an email. There has to be a procedure, there has to be a method to it. Sometimes they will refuse to come. So how do you do it? So this is the procedure which we have been laid down in section 31, and it helps us understand how summons can be served to the witness. Appearance of the parties and effect of their non-appearance in the party. This is very important. Ex parte order, I would call it, order 9. So what happens when the party doesn't come to the court? In spite of the fact that he served, they miss out coming to the court. So we'll deal with this. Introduction. Order 9 of the court provides the law with regard to appearance of the parties to the suit and consequences of their non-appearances, where a party, plaintiff and defendant both, does not appear. When the suit is called on for hearing, the suit may be dismissed, or where the party defendant does not appear, even when the summons is duly served, the court may order for an ex parte hearing of the suit. Because I've seen in my own personal experience, many a times deliberately the defendants don't want to come before the court, either with a motive to show that they haven't received the copy of the claim, they haven't been served upon, or with the motive that they want to delay the proceedings. So adjournments given to a little level is fine, but if they continuously do not come, and if we can prove that yes, we have served properly, the ex parte hearings can begin from the court. It's upon the court's discretion, and court would generally do so if deliberately the defendant is avoiding the hearing. So we would see how it works now. Therefore, order 9 can be discussed under following heads. Dismissal of the suit. The plaintiff suit may be dismissed under the rules 2, 3, 5, sub rule 1 and 8 of order 9, while the court may order past ex parte hearing of the suit under rule 6, sub rule 1 of order 9. So now what is rule 2? A suit may be dismissed under rule 2 if summons has not been served upon the defendant due to the failure of the plaintiff to pay the court fees or postal charges, if any chargeable for the service, or the failure to present the copies of the plaint as required by the rule 9 of order 7. So now rule 3 is important. The court may dismiss the suit under rule 3 where both the parties are absent when the suit is called out for hearing. Then rule 5, the court shall pass on an order for dismissal on the suit under rule 5.1 where the summons has been returned unserved on the defendants and the plaintiff fails to apply for a fresh summons for a period of 7 days from the date of the return of the summons made to the court for serving the procedure. But the court shall not dismiss the suit under Rule 5.1 if the plaintiff satisfies, as I've just mentioned earlier, that he has failed to appear after using his, like he has failed and this defendant does not come forward. Plaintiff has taken great attempts by serving and discovering where the defendant is residing, and in such a case he cannot see is deliberately not served well. Such defendant is avoiding service of the process if the plaintiff proves that or shows before the court that I have tried, but he's deliberately not accepting. So that's one way where the court will not dismiss it. There is any other sufficient cause of extending the time and may extend the time for making such application. And Rule 8, the court shall make an order of dismissal of the suit under Rule 8 where the plaintiff remains absent and the defendant is present. When the suit is called for hearing, the defendant does not admit the claim and thereof. So it's a both-way proceedings. Remedies against dismissal. Now, what do I do if the suit is dismissed? Where the suit has been dismissed under Rules 2 or 3, the plaintiff has remedy either to file a fresh suit subject to the law of limitation under Rule 4 or to make an application under Rule 4 for restoration of the suit. So many times it happens the matter is called out on the board and, for a couple of occasions, the plaintiff is not aware that the matter was called out and is dismissal on appearances. But then later on when they see the order uploaded on the site, they may apply for restoration and they may show the court how they've missed out appearing. So this is a practical example which I'm giving. Not that it's a generic one. It could happen many a times that is dismissed on the grounds of non-presence, and the non-presence could be not that deliberate non-presence. So it depends on the case to case, and restoration can be possible. When the suit has been dismissed under Rule 5.1, the plaintiff may bring a fresh suit subject to the law of limitation. When the suit is dismissed under Rule 8, the plaintiff shall be precluded to bring a fresh suit on the same cause of action, but he may apply to set the dismissal aside under Rule 9 of Order 9, and the court shall, after issuing the notice of the application on the opposite side, set aside the order of dismissal on being satisfied and there was sufficient cause for the plaintiff for non-appearances. So this is how even the dismissals play the role. And ex parte, now I'm going to specifically invite your attention to ex parte hearing, where only the plaintiff appears and the defendant does not appear. When the suit is called on for hearing, the court observes that the summons was duly served on defendant, then the court may pass an ex parte hearing. And again, the remedies are same. The defendants in the same manner may be allowed to the court to be heard as if it had appeared and his non-appearance was taken into consideration. Ex parte hearings can again be put forward and court may consider that yes, now the defendant has appeared and this ex parte hearing can stop through also. But they have to satisfy the court why they had missed out hearing. That's very important. Now, how do you set aside the ex parte hearing? Where in an ex parte hearing, a decree is passed ex parte against defendant, he has the following options. To apply under Rule 13 to set aside the ex parte decree, and the court after service of notice of such application on the opposite side, and on being satisfied that the summons was not duly served on the defendant, or he was sufficient cause from not appearing before the court. So this is one way that he can apply for setting aside the ex parte order. Then interest, as now I will deal with cost and interest. Many a times we see the court is really not in a favor of entertaining some frivolous petitions. Some petitions which have really no stand, and court is like you're wasting court's time. Impositions of cost comes, interest comes. Sometimes when the party is asking for compensation, damages, and whatnot. So depending on the reliefs, let us see what is interest as defined in the section 34 first. Wherein so far as the decree is for the payment of the money, the court may in the decree order interest as such as the rate of the court deems reasonable to be paid on the principal sum decided for from the date of which the suit to the date of the decree, in addition to any interest decided on such principal sum for any period prior to the institution of the suit, but not exceeding the rate of 6% per annum as the court deems reasonable. So this is something we read in section 34. Now section 35 is about cost and the provisions which grants rights to the discretion of the court. It may grant order for paying the cost of the winning party and expenses incurred in maintaining the suit, or to pay the amount that the winning party has incurred while drafting the legal notices. So this could be the reason, the court can sometimes feel like, yes, the matter is disposing of, but with cost, or I'm dismissing with cost, depends on what the payout for the cost has been claimed for. Or sometimes when it's not paid for, the court suo motu would feel it is a necessity to impose cost because n number of dates have been given, or n number of adjournments have been given for a small issue which has wasted a court's lot of time. So depending on the situations, the cost can be imposed upon. Now, compensation in respect of false and vexatious claims under 35A, it happens in any suit or proceedings, including an execution proceeding, but any party objects to claim of the defense on the ground that the claim or defense or any part of it is against the objector, false or vexatious, in nature, the knowledge of the party who knew that he had to put forward and he has not done it. Court may impose compensation in respect of this and may impose even additional costs. So it depends facts to facts. Cost for delay is also being imposed many a times that you are deliberately delaying, as I just said earlier. So this sort of things we should know, and miscellaneous costs under 20A, order 20A, it's very important. A very small line of it makes specific provision which regard the power of the court with respect to expenses incurred during typing, notice, drafting. Many a times they do ask miscellaneous cost, and they do get it. So depending on the cost of expenses. So now with all this understanding of the entire three sections of which I have dealt with in my lecture, I would say important topics from the examination points of view would be obviously pleadings. Please take a note of it. I'm not saying this would come in the examination, but I'm saying that as a student, you should study it thoroughly. Definitions of decree and order would be important. You need to know what kinds of decrees are there, the three kinds of decrees which I have dealt with. You also need to know the difference between res judicata and res sub judice. You need to know what is substituted service. You need to know what is appearance in person in party, the differences of the same. You need to know what is ex parte order, which I've just dealt with. I'm giving you all these pointers of the answers which you can prepare in more thoroughly format, obviously taking into consideration the latest judgments which you need to look out and pull in your answers. We do not have much time, so I was unable to put forward relevant judgments, but you will definitely get more judgments to make your answer more colorful and interesting for the examiner to read. So with that, I would say all the topics I've dealt with are quite relevant when I saw the question papers of the past years. And if I've missed out something with the time constraints, I'm unable to cover it. So in nutshell, how do we draft now would depend on our theoretical knowledge. What we need to put, take information from your clients, take information from your parties in detail in a written format, put facts correctly, and then accordingly think about the prayers which we can feasibly and practically get, and incorporate those prayers in your reliefs. Because if you draft something which is not acceptable and which the court would not be able to grant the relief for, it really would not satisfy the entire process of litigation which you are going to take forward before the court. Now, our High Court rules, have a lot of amendments also many a times by the procedural notes which the High Court website produces. Sometimes we have it from the registry. So keep your minds on it as respect to notice of motions, chamber summons, etc. You need to see it's an IA now. So those rules you'll have to read through from the High Court website, I would suggest. And to conclude, I would say in the summary of my part of what I have today just given you an overview, I would say emphasize on clarity of understanding. Put your points in keynotes, and then elaborate it. Because if I am a student, I have written my papers like that. I'm just giving you a few tips. It's not that what I'm saying is the truth and only truth, and this is how you could score. You have to find your own ways. This is just a clear, simplified method which I'm saying. If you're going to write 2-mark answer, you should know how much portion you should put in. And if you're going to write a 12-mark answer, you should know how much examples you should add in, what case laws you should put in. So be prepared for it. And CPC and practice procedure is day-to-day practice material, which we need to see it evidently even in the court when we are appearing. So the summons part of it, the service part of it, we see every day in our day-to-day hearings. So I would say keep yourself more active from the practical readings and write your examination that yes, you are a well-trained lawyer and you know what civil proceeding is. Don't get really tense. Go slow with it. Go easy with it. It's not that difficult. It's just that concepts need to be clear and concepts need to be turned out rightly with proper case laws. That is my suggestion. I'm not saying this is what is expected. This is what a student should prepare for. So with this, I must thank Honorable Secretary Nilesh Modi sir and Mr. Jani sir and others who have been part of this lecture. And I would like to sum up. If any problems or any difficulties, Mr. Jani can always, through his association, can ask me to help people. I'm ready to help. Yeah. So thank you very much.
Thank you, Dhruti. Aja, don't leave. There are some announcement I want to make. So don't leave. If people are leaving early, then that is a disadvantage to you guys. So you must stay. See how Dhruti has just now given you so many tips of how to write an exam. This will come only at the end. So you must stay on. Now I am also wanting two, three things. One is Dhruti has covered the topic partially, but very nicely. And if you have realized, I don't know if you have realized, if you have studied on your own, CPC is a vast topic. You would have studied CPC differently and High Court rules separately. She has tried to correlate the sections of CPC, the orders, and the High Court rules very nicely, so that what relates to plaint has come in, what relates to written statement has come in, and like that she has proceeded. Very good, Dhruti. Thank you so much. Now, one more thing. She must have mentioned to you that High Court rules has been amended, and instead of notice of motion and chamber summons, now it is interim applications. We are in the process of considering amending the syllabus, so do not just ignore it. You study that also. It may be possible that in your exam, interim applications would be covered in the syllabus. So do not forget about that and do study about that. Now, next Saturday, this Saturday, we are having the remaining portion of CPC except Order 21. Order 21 is very large. It relates to executions. So we have decided to keep that separate, and there will be a separate speaker for that. But from Order 22 onwards, we have Mr. Rajmani Verma, another solicitor coming in, who will speak on that. Stay on. Now, I forgot to mention that Dhruti is also an expert in IPR and other laws, what technical laws you said, no? Something like that?
Technology, sir.
Technology laws or some.
Like cyber laws, yeah.
And she is also a lecturer and an author. So I forgot to mention that she has a lot of, and she's at present in the chambers of Senior Counsel Sailesh Shah. Thank you, Dhruti. And thank you all for joining. Please stay on every time till the end of the session. Do not leave early.
Okay? Thank you so much, sir, for having
me. Saturday. Thank you, Mr. Jani, too. And see you all on Saturday now. Thanks. Bye.
Thank you so much, sir, for this this seminar that you are taking all your pains to put in for the students. I hope we'll see many more solicitors coming out now. Thank you so much.
Bye. Bye. Thanks a lot, Dhruti. Bye.
Thank you. Bye. Bye.